Program Director, Mr. Sekhalwe, Advocate Galeka, the Deputy Public Protector, the staff of the Public Protector, the people of South Africa, members of the media, ladies and gentlemen, thank you for honoring our invite. We have called this briefing today to inform the public about the progress we have made on a few investigations that we recently concluded. As you may be aware, the publications of our findings is informed by Section 182(5) of the Constitution, read with Section 8, subsection 1 and 8, subsection 2, capital A, and small a of the Public Protector Act. Only 3 reports are on the agenda this afternoon. 2 of the 3 are, they are closing reports. This denotes reports which results from cases that are no longer being pursued on the grounds that the allegations, giving rise to the allegations, are unsubstantiated, or giving rise to the investigations are unsubstantiated, or that we do not enjoy jurisdiction, or that other competent forums are seized with the same matters, or the matter is then decided by a court of law. And the third is a final report is a formal report in which we have made adverse findings against the respondents and proceeded to take appropriate remedial action as envisaged in Section 182, 1C of the Constitution. Let's start with the first 2 reports. The first closing report relates to Mr. Vavi on behalf of Chetia versus Godan and others. It's report number 48 of 2021-2022. We investigated allegations of failure by the Minister of Public Enterprises, Mr. Godan, which is an allegation, the Board of Directors of Eskom and Eskom Holding, to investigate a complaint relating to various allegations of maladministration and improper conduct against Mr. Oberholzer and subsequent improper application of the Protected Disclosure Act 26 of 2000 as amended. Mr. Vavi lodged the complaint on the 10th of September 2020 on behalf of Mr. Mark Chetia, who was an employee of Eskom. In essence, the complaint alleged that he made a protected disclosure in June 2019 to the Commission of Inquiry into State Capture regarding certain contracts entered into between Eskom and a number of construction companies, citing the 42 million contract with Aveng Africa as the one which points to corruption, abuse of power, nepotism, and corporate mismanagement, for which the complainant is now being victimized by Eskom. Eskom entered into a contract with Aveng Construction, which obligated Eskom to pay an amount of 42 million to it, although such payment was not warranted. So the commission recommended that Eskom should not pay this claim, and a similar conclusion was arrived at by an internal audit commissioned by the complainant. Serious allegations that the complainant had made against the Chief Operating Officer, Mr. Oberholzer, were also not dealt with, despite having been brought to the attention of the Minister of Public Enterprises, Mr. Godan. He sent letters to the chairperson of the Public Enterprises Portfolio Committee, Honorable Mr. Makakwa MP, and the chairperson of the Standing Committee on Public Accounts, SCOPA, Honorable Mr. Hlengwa MP, wherein he expressed his concern about the state of affairs at Eskom. On 12 and 18 March 2020, the South African Federation of Trade Unions sent correspondence to the chairperson of the board of Eskom, Professor Mkhwebane, requesting that he should act on allegations of misconduct lodged against Mr. Oberholzer. The allegations leveled against Mr. Oberholzer included, inter alia, that he participated in meetings and supported the extension of a contract between Eskom and Stefanuti Stocks, yet he failed to disclose that he owned shares in that company, and that Mr. Oberholzer had pressed for the payment of 42 million to Aven Construction by Eskom, despite the latter not performing in line with its required contractual obligations. Following the complaint which the complainant had lodged with Professor Mkhwebane, Eskom appointed advocate Kasim SC to investigate the allegations of impropriety and corruption leveled against Mr. Oberholzer in various digital media publications in order to prepare and submit a report with his findings and recommendations to the Board of Directors of Eskom within 10 working days of receiving the brief. Mr. The investigator, which is Kasim SC report, was full of inconsistencies and contradictions. That's what the complainant is alleging. And he attached a copy of the said report for ease of reference. So the complainant mentioned that Kasim SC recommended that, quote, to enable a proper ventilation of this issue to be determined, more so having in mind the intervention of representatives of the Zondo Commission you have made, it would appear certain preliminary findings on this very issue. Eskom must factor into consideration that such payment is presently part of litigation between Eskom and Aven. However, in the interest of transparency, accountability, and fair play, there is no reason why this issue cannot be subject matter of a disciplinary hearing. After 2 months of submitting the said report to Eskom, Kasim SC submitted a follow-up report in which he recommended that the disciplinary action proposed against Mr. Oberholzer be held in abeyance until a High Court litigation initiated by Aven Construction against Eskom is finalized. In September 2019, the complainant lodged a grievance against Mr. Oberholzer in terms of Eskom internal grievance policies. Subsequently, a disciplinary hearing was held in October 2019, and the outcome of the hearing was submitted to Eskom, wherein both parties considered the matter closed and concluded that the grievance was finalized. In January 2020, Mr. Oberholzer charged the complainant with unfounded allegations against the COO during the grievance hearing. And this was contrary to Eskom's grievance procedure, which provides that no employee or representative shall suffer any prejudice or victimization as a consequence of lodging a grievance or attending to one. So this is still an allegation. So in January 2020, the complainant was on sick leave, and he alleges that Mr. Oberholzer informed him through an email that he has been transferred from Group Capital Division to Human Resources with effect from 1 February 2020. The complainant mentioned that his medical condition was as a result of the victimization from work. Subsequently, the complainant lodged a complaint of unfair labor practice with the Commission for Conciliation, Mediation and Arbitration, CCMA, for his unilateral transfer. The conciliation process of the matter was held on 13 March 2020, wherein Eskom attempted to offer the complainant compensation provided that he resigns from Eskom. In April 2020, the Group Human Resources Executive of Eskom, Ms. Pule, informed the complainant to report to his new portfolio position and fulfill his new obligations as expected. And failure to do so would result in further disciplinary action against him. The complainant alleged that throughout his employment with Eskom, he received an exceeded score for his performance assessment, and his performance was recognized in the form of merit awards. Mr. Oberholzer and Mr. Manjanja made various statements to the media wherein they mentioned that the issue concerning the complainant was his poor performance at work. That Eskom made an announcement that it was bringing back 60 white retired engineers as it was facing a shortage of engineering skills, yet it is transferring him with 20 years of technical and strategic experience at Eskom from operations to human resources. And on the 10th of September 2020, the complainant approached us to intervene and investigate his complaint against Eskom. Following a thorough assessment of the complaint, including a preliminary investigation through which we sought to determine the merits of the complaint and decide how the matter should be dealt with, we decided to focus on whether Minister Gordhan, the Board of Directors of Eskom Holding, failed to investigate the complaint relating to various allegations of maladministration and improper conduct against Mr. Oberholzer and improperly applied the PDA, Protected Disclosures Act. And if so, whether such conduct amounts to maladministration and improper conduct in terms of Section 6(4) of the Public Protector Act. Our investigation revealed that the allegation that Minister of Public Enterprises, Mr. Gordhan, the Board of Directors of Eskom and Eskom failed to investigate the complaint relating to various allegations of maladministration and improper conduct against Mr. Oberholzer and subsequent improper application of the PDA is unsubstantiated. Eskom investigated the complaints lodged by the complainant relating to various allegations of maladministration and improper conduct against Mr. Oberholzer and issued 3 reports, which were Mkhwebane SC report dated 31 October 2019, Kasim SC report dated 4 April 2020, and Eskom report dated 24 August 2020, respectively. The said reports exonerated Mr. Oberholzer of various allegations leveled against him. So the complainant referred the issue of unfair labor practice and alleged subsequent occupational detriment suffered after he lodged a protected disclosure to the CCMA on the 18th of February 2020. The CCMA issued a ruling on 9 November 2020. The matter was dealt with by the CCMA in line with the provisions of Section 141 of the Labour Relations Act. If the complainant is not satisfied with the outcome of the CCMA ruling, he should refer the matter to the Labour Court as required by Section 1414 of the Labour Relations Act. Therefore, the Public Protector does not have jurisdiction to review the ruling of the CCMA. Consequently, the issue relating to allegations that Eskom entered into a contract with Aveng Construction, which obliged Eskom to pay an amount of 42 million to it, although such payment was not warranted, was decided by the South Gauteng High Court on the 11th of September 2020, wherein Eskom was directed to pay Aveng Construction the amount of 40 million together with interest. By virtue of Section 6, subsection 6 of the Public Protector Act, the Public Protector cannot investigate court decisions. Further, Eskom denied that they ever had any project name or the entire project. As such, it could not comment any further on the matter. Therefore, we could not find that the conduct of Eskom constitutes improper conduct as envisaged in the Constitution or maladministration or abuse of power as envisaged in the Public Protector Act. Accordingly, we are unable to make any findings or take any remedial action in light of the aforegoing. We have therefore decided not to pursue the matter any further and thus finalize it by a closing report. The second report we are issuing is a closing report as well, Gade versus Mahumapilu, report number 36 of 2021-2022. We investigated allegations of the violation of the Executive Ethics Code by the former Premier of the Northwest Provincial Government, Mr. Mahumapilu, in relation to his alleged facilitation of the delivery of Bonsmara cattle to the former President, Mr. Jacob Zuma Homestead, through Agri-Delight Training and Consulting. The report relates to an Executive Members Ethics Act complaint lodged with the Public Protector in terms of Section 4 of the Executive Members Ethics Act on the 23rd of April 2018 by Mr. Gotrich Gade, the former Secretary General of the EFF and the former Member of Parliament. The complaint was based on a Sunday Times newspaper article on the 22nd of April 2018, in which it was reported that a head of cattle costing 1.5 million and meant for emerging farmers was instead delivered to Nkandla as a gift to Jacob Zuma from his political ally Northwest Premier Super Mahuma Pilu, and that the generous gift paid for with public funds is under investigation. Mr. Gade stated in his complaint that he would like to draw the Public Protector's attention to the particular involvement of the then President of the Republic, Mr. Zuma, on the receipt of stolen goods and current Premier of the Northwest, Mr. Mahuma Pilu's abuse of public trust and fiscus for private benefit. Mr. Gade did not allege the violation of a specific clause in the Executive Ethics Code, apart from indicating that the complaint was lodged in terms of Section 4, subsection 1 of EMIA, and requesting the Public Protector to investigate the receipt of the cattle by the former president and the involvement. We focused the investigation on whether the former Premier, Mr. Mahuma Pilu, violated the Executive Ethics Code in respect of his alleged facilitation of the delivery of Bonsmara cattle to the former president's homestead, and if so, whether such conduct amounts to improper conduct. We found that the allegation that the former Premier violated the Executive Ethics Code through his involvement in the facilitation of the delivery of the Bonsmara cattle to the former president is not substantiated. From the evidence sourced independently and also provided to the Public Protector, it is apparent that the former president did receive the cattle from Agri-Delight as confirmed by the payment made for the cattle by Agri-Delight. The delivery of the cattle and the submission of the Agri-Delight Managing Director, Mr. Munswe. Although Mr. Munswe contends that he personally donated the cattle to the former president, his use of the Agri-Delight's FNB account and not his personal account to pay for the transaction does not support his version. However, the matter pertaining to Agri-Delight's flow of funds under Mr. Munswe's management is receiving the attention of the law enforcement agencies. To this end, the Directorate of Priority Crime Investigation and the Asset Forfeiture Unit assist with the matter. It is also clear from the evidence relating to the payment made for the delivery of the cattle that the department itself did not fund the payments for the said donation and delivery of cattle to the former president. Therefore, no state funds were utilized for the payment and delivery of cattle to the former president, which would have indicted the Public Protector to investigate and pronounce on that in line with her mandate and jurisdiction. There is also no evidence to indicate that the former Premier abused public trust and the fiscus for his private benefit, thereby violating clause 2.1 and 2.3 of the Executive Ethics Code. In line of the aforegoing, we have therefore decided not to pursue the matter any further and thus finalize it by means of a closing report and the involvement of the former Premier. We investigated allegations of undue delay by the National Department of Health to address the challenges experienced by clinical associates and to process the report of the Clinical Associate National Task Team 2017 for consideration and possible approval. The investigation resulted from a complaint lodged on 26 April 2019 by Mr. Sanele Ngobo in his capacity as the Clinical Associate and Secretary General of the Professional Association of Clinical Association in South Africa, called PACASA. Clinical associates are mid-level healthcare workers who work under the supervision of medical doctors, caring for patients. In most cases, they work in disadvantaged and rural areas. In the main, the complainant alleged that the introduction of the clinical associates profession into South African healthcare system came about as a result of the recommendation of the PEAK report for human health resources in 2001, which recommendation was endorsed by the erstwhile Minister of Health, the late Dr. Shabalala Msimang, in 2002. Since inception of the profession, the first cohort of clinical associates began practicing in January 2011. To better understand the value and future of clinical associates as a medical mid-level worker, the department established a clinical associate national task team. Its brief was to review what has been learned over the past 10 years of training over 900 and appointing almost 700 clinical associates, and how this applies to the current challenges faced by the health system. The work of the task team culminated in the report of the Clinical Associate National Task Team 2017, the Clinical Associate Training and Profession, Current Successes and Future Steps, which we will call the task team report. The report was intended to aid the department in formalizing the way forward for clinical associate with the approval of the National Health Council. The report addressed several key issues relating to the clinical associate profession and outlined recommendations for these challenges being experienced by clinical associates. Since the finalization of the report, however, the department has delayed or failed to adopt the implementation of the recommendations therein. Thus, the challenges experienced by the clinical associate relating to integration within the health system, conditions of service, and their development continue to persist. It was Mr. Ngobo's contention that the complainants were, in the circumstances, aggrieved by the conduct of the department as set out above, and requested the intervention in the matter. Having studied the complaint thoroughly, we decided to focus the investigation on whether the department has unduly delayed to address the challenges experienced by the clinical associate and to process the task team report for consideration and possible approval. We found that the allegation that the department has delayed to address the challenges and to process the report was substantiated. There was undue delay on the part of the department in taking the report through for its consideration and possible adoption following its completion in 2017, including relevant governance structures such as the internal audit and audit committees. It has been considered that the subpoena deliberations, during the subpoena deliberations on the 9th of June 2021, that the report never served before the Executive Committee or before the National Council, Health Council. Hence, the undertaking from the department that the report will now be taken through the appropriate channels for proper consideration. It is further noted that the undertaking comes approximately 4 years after the finalization of the task team report and only after the intervention from the Public Protector's Office. The department considered that through its submission to the Public Protector that there was a lack of formal communication with the complainants, particularly regarding the challenges which gave rise to the non-implementation of some of the recommendations of the task team report. In this regard, it was noted that the concession was further accompanied by the undertaking that going forward, the department will make the effort to communicate with the complainants regarding this matter, particularly to ensure that they formally engage with complainants by 16 July 2021. So that's one of the interventions. And in terms of Section 195(1)(a) of the Constitution, a high standard of professional ethics must be promoted and maintained, and development orientation should have been promoted and adhered to in sculpting a way forward for the profession since the time of its inception. Where challenges presented themselves in the adoption and implementation of the recommendations contained in the task team report, the department was required to act with transparency as required by Section 195(1)(g) of the Constitution, by making known to the complainant who are most affected by the issues of non-implementation of the report, and for the purpose of displaying accountability and ensuring that the needs of the complainants are responded to in line with the recommendations as set out in that task team report. The department acted timeously and appropriately upon receipt of the task team report and ensured that it went through the appropriate channels for consideration and possible adoption. the department would have displayed good human resource management and career development practices to ensure that human potential is maximized and cultivated as required in terms of Section 195, 1H of the Constitution, in ensuring that the report is properly dealt with. In terms of Section 3, subsection 1C of the National Health Act, the Minister of Health must, within the limits of available resources, determine the policies and measures necessary to protect, promote, improve, and maintain the health and well-being of the population. So the National Department has, since its inception of the clinical associate profession into South African health system, being enjoined to provide policy determination and strategic way forward for clinical associates, in as far as they were introduced for the purposes of the betterment of the health system. However, observing from the issue giving rise to this complaint, there has not been a proper way forward to facilitate adequate integration and development of clinical associate profession. That is, through taking the tasking report through the Executive Committee and the National Health Council for way forward to be established for clinical associates. Furthermore, there was evident neglect by the department to take the report through appropriate governance structures. And the conduct of the department accordingly constitute improper conduct as envisaged in the Constitution and maladministration in terms of the Public Protector Act. To remedy this improper conduct and maladministration, the Minister must ensure the following: as undertaken by the department, that there would be formal engagement with the complainants pertaining to this matter. The department is to, within 30 working days of this report, furnish the Public Protector with the records pertaining to the engagement, and they, where applicable, furnish the Public Protector with the record of any other subsequent engagement relating to the matter therein. Regarding the undertaking made by the department to re-engage the Department of Public Service and Administration to motivate for a holistic review of the occupational specific dispensation as a remuneration framework in the public health sector that is inclusive of clinical associates and sustainable, the department is to, within 60 working days of the date of this report, furnish the Public Protector with feedback regarding the outcome of that engagement. Should the salary structure be included in the OSD, then the department should also ensure that corresponding costs related to the compensation of employees should be met within budgetary allocations or the vote in order to avoid unauthorized expenditure as required in terms of the Treasury Regulation 8.3, read with the PFMA Section 76 for B, and Treasury Regulation 9, read with the PFMA Section 38.1 G and 76.2E. Regarding the undertaking made by the department to convene a meeting for purposes of synthesizing the task team report with the executive authority and provincial departments, together with the undertaking to report back on this engagement, the department is to, within 60 working days to date of this report, furnish the Public Protector with feedback accordingly. And regarding the undertaking made by the department to conduct a review of the program performance thus far to assess various aspects of the program, including uptake since its establishment, the impact on health services, career pathing or advancement prospects of clinical associates, status of mid-level policy interventions generally, and other parameters that may be of relevance to guide decisions on the program. The department is to, within 30 working days of the date of this report, provide us with feedback on the review proposal tabled with the National Health Council on the 18th of November 2021. In line with the proposal made by the department for the process to be followed for review, the department is, within 30 working days of this report and thereafter every 60 days, provide the Public Protector with monthly reports on the procedure set out for the review of this whole process of clinical associates. The following approach to the review was proposed by the department, which they will finalize and sign off terms of reference for the review in consultation with the relevant stakeholders to be completed by the 31st of March 2022. Avail funding for the review process during this financial year, which is 2022-2023. Source the service provider to perform a review using both quantitative and qualitative methodology immediately after the signing of the terms of reference by January 2022. Conduct and finalize the review by 30 November 2022. NAC to sign off the recommendation and publish them by March 2023. So the department to source funding to implement the resolution of the NAC during the MTEF in October 2022 for the 2023-2024 financial year, and the department to implement the resolution of the NSHSC during the year financial 2023-2024. So regarding the undertaking to engage with the Health Professions Council of South Africa to request that the matter of prescribing rights be finalized without further delay, the department is to, within 30 days of issue of the final report, provide monthly progress reports regarding this matter until its conclusion. We are pleased with the Minister of Health's exemplary cooperation during the investigation, especially the current minister, and his commitment to implement the remedial action. We look forward to the implementation of the remedial action so that we can take the complainant as close as possible to where they would have been had it not been for the improper conduct and maladministration. We are available to assist with the implementation. Thank you, ladies and gentlemen, for your indulgence. Copies of these reports will be shared with the affected parties shortly. The public will also be able to access the copies through our website. We will take questions, if any, clarity, if any, on these reports.
Thank you, Mr. Tshale. I think the emphasis really is to really call upon other state institutions to really take the example that has been done by the Minister of Health. Firstly, upon his appointment, ensuring that he speedily responds to the preliminary report provided by the Public Protector, but internalize the matter, which has been long outstanding with the Department of Health, and ensure that the matter at least is amicably resolved by meeting us in respect of the remedial actions that we had proposed to him. And by the time of releasing this report, actually providing us with the implementation plan, which has been read out by the Public Protector. In so doing, really, it does help to uphold the Constitution, to support the mandate of the Public Protector as provided for by the Constitution, but also ensure good governance within his own department, which is really an issue that other state institutions are indeed grappling with. So we really call upon specifically executive authorities to really take up the opportunity provided by the Public Protector South Africa to ensure that we participate towards ensuring good governance and eradicate all malfeasance and maladministration within state institutions. I thank you.